Magandang umaga po sa inyong lahat. The joint public hearing of the Committee on Public Order and Dangerous Drugs, the Committee on Peace, Unification, and Reconciliation, and the Committee on Finance is resumed. For the committees, allow us to state that, number one, invitations anew have been made to individuals requested to be present today. The MILF Mohager Iqbal for the PNP and also the PNP Controller, who I understand is present here today. For the retired PNP ARMM Chief Superintendent Noel de los Reyes. Senior Superintendent Mendez was informed of the hearing, but per the request of the PNP and some members of the committee should be invited to an executive session, citing that the officer is handling key sensitive intelligence and information pertinent to national security and strategies. The committees will discuss this issue in a separate meeting. On the documents requested to be subpoenaed, I understand that the PNP and the concerned agencies will bring those documents hopefully submitted by today. Number one, the copy of the warrant of arrest for Marwan as requested by Senator Soto from the Board of Inquiry Chair Magalong. Number two, the intelligence packet as requested by Senator Honasan from the PNP, which the chair will have to examine first to determine whether this packet can be divulged to the public or should be part of our official documents. In addition, the approval sheet of the Operation Exodus, the PNP SAF after operations report, and the communication net annex as requested by Senator Marcos, also from the PNP SAF to submit. The operation plan as requested by this representation, the PNP or Director Napeña should also submit this. We have for today additional invited guests, Chairperson Loretta Rosales of the Commission on Human Rights. As we resume the interpellations, may we remind the members that 5 minutes per question is allotted per senator, and you will have a chance to ask more questions in the next round. And before we start with our interpellations again, may we request Secretary De Lima if she can. I think she has a presentation on the legal framework for the Mamasapano incident. I think that we will be guided greatly by this because we are also constrained by several legal provisions. So we will ask for her presentation. The sequence of questioning will be Senator Drilon, to be followed by Senators Binay, who I think will give her time to Senator Honasan, if ever. Senator Recto, Aquino, Pimentel, Cayetano Alan, Villar, Cayetano Pia, Angara, Legarda, Osmeña. And the questions submitted, Senator Bina Marcos. And the questions submitted by Senator Revilla. For those who weren't present here today, magsitayo po tayo para gawin ang ating panunumpa. I think Honorable Rosales, yung mga wala po kahapon at yung mga hindi po sigurado sa kung ano yung sinumpaan ninyo kahapon, tumayo lang po muli.
May I request those resource persons who were not present yesterday and those who were not able to take their oath yesterday to please stand up and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this investigation in aid of legislation on the Mamasapano incident? I do. For the record, Madam Chair, the resource persons affirm their oath.
Salamat po. I would like to acknowledge the presence again of Senator Rojas. Thank you for taking the time, sir. I know that you're Secretary Rojas, I'm sorry. Thank you for taking the time, sir. I know that you're busy also with the state visit of the Indonesian delegation. I would also like to acknowledge the presence of Secretary Gazmin, Secretary Ging Deles, Secretary Laila De Lima, and all the other members from the local government who may be present here today, the members of the PNP and the AFP. Also, Honorable Rosales, Chair of the CHR. Yesterday, we discussed the chain of command issues, the questions as the involvement of the MILF. I would like to ask the representative of the MILF if perhaps we will have today the presence of Mr. Iqbal, and then the glaring communication inefficiencies of the equipment and coordination procedures, and of course the participation of Mr. Napeñas and also Mr. Purisima. So to begin, I would like to ask the MILF panel, the MILF representative who will be here today. Is it still you, sir?
Magandang umaga po, Madam Chair, Your Honors. Meron pong letter galing po sa kay Chairman Iqbal, address po sa kagalang-galang na Senator Grace po to the Senate, pursuant to the instruction of the Central Committee. At yung letter po ay sinabmit na po yata o binigay na po yata ni Atty. Raisa Jajuri. Nagsasabi po na and explaining na hindi po siya makakapunta, pero meron siyang commitment that he will appear. At kung mamarapatin po ng kagalang-galang po, Your Honor, with your pleasure, kung babasahin po ba namin yung sulat o ano po ang inyong disposition po, Your Honor. Thank you po.
Please po, pakibasa po yung kanyang liham. May kopya po ako pero dapat po malaman ng mga kasama natin. Go ahead, sir.
Thank you po, Madam Chair, Your Honors. 09 February 2015, Senator Grace po, Chairperson, Committee on Public Order and Dangerous Drugs, Senate of the Philippines. Dear Senator po, we thank you for your committee's kind invitation for us to attend the joint public hearings of the Committees on Public Order and Dangerous Drugs and Peace, Unification and Reconciliation on Resolution 133, 134, and 1135, all relating to the incident which happened at Mamasapano, Maguindanao on January 25, 2015. Please be assured that the More Islamic Liberation Front is fully committed as the Senate is in the search for truth and justice. Please bear with us as we engage with the institution of the Philippine Senate, especially for the first time. The MILF is a revolutionary organization. While we may have signed a peace agreement with the Philippine government after 18 years of intermittent war and negotiations, that peace agreement has yet to be implemented. Until the peace agreement is fully implemented, we will remain to be a revolutionary organization. Accordingly, the Central Committee of the MILF has accepted your committee's invitation and has designated me to appear in its behalf. However, the decision has stressed that the appearance will take place after the MILF Investigation Commission comes out with its findings, which will be the basis of my statements to the relevant committees of the Senate. Further, the MILF also requests that my appearance should be in an executive session. I take this opportunity to inform Your Honor that the MILF has decided to return the firearms and any retrievable personal effects of the fallen SAF PNP in deference to the peace process and recognition of the MILF that it never wanted that unfortunate incident on January 25 in Mamasapano, Maguindanao to happen. This was the first time since 2011 that fighting erupted between the government and MILF forces. Perhaps in a couple of days, the MILF will be able to finish the internal process of accounting of the materials to pave the way for the return. The chair of the MILF's Committee on Cessation of Hostility, CCCH, Mr. Rasida Jasan, will again represent the MILF his capacity. He would be accompanied by Attorney Raisa, the jury, a member of the Bangsamoro Transition Commission, and Mr. Boots Panugel, who is also a member of the CCCH. Again, I would like to apologize for my inability to attend your committee's hearing tomorrow for reasons aforecited. Thank you very much. Signed, Mohag Iqbal, Chairman, Bangsamoro Transition
Madam
Commission.
Chairman, this is may I just interrupt? But am I correct in hearing, and is my interpretation correct, that in the view of Chairman Iqbal, until the Bangsamoro government is formed, that we are still at war with the MILF, or the MILF continues to be a revolutionary organization? So they are still fomenting revolution until the peace agreements are completed. Is that the interpretation? Is that a correct interpretation, Madam Chairman? Would you?
See, actually, we appreciate your presence and we thank you for being here today. We respect that you have your own fact-finding committee. What we are asking is not a complete report. We are asking for your initial assessment. Everybody here is giving also their initial assessment. So my question is, I'm not even sure if you're authorized to answer the question of Senator Marcos, because this will really have to be answered by your leadership. And that is the reason why we are asking him to be present here today. I understand he sent representatives, but may we ask when perhaps your own investigation will be done, when he might be expected to be here? That's the first question. The second question, yes, you have your statement here that you will return the arms or other equipment from our fallen soldiers, fallen police officers. On the other hand, there are other nagging questions at us. For example, who were actually involved in the firefight? And were you actually informed by the peace panel if you should engage or disengage from the firefight? These are questions that can only be answered by your top leadership. So we would really appreciate your presence. But if you have any partial answers as to the question, and this is highly sensitive, this particular question of Senator Marcos, but if you have any particular statement about it or if you've heard anything about it, please reply.
Your Honor, Madam Chair, I am not in a position to respond. I think the letter of Chairman Iqbal is enough for me to say that he will represent the MILF for the hearing in Senate, and but we are very committed in the peace process with whatever the panels. I think the communications, the parameters, and the ways the panels will work on this are open between the government and the MILF, and it's up to the Honorable Senate what would be the pleasure, and thank you again.
Madam Chair, I would just like to read the part of the letter that we have just heard. The MILF is a revolutionary organization. While we may have signed a peace agreement with the Philippine government after 18 years of intermittent war and negotiations, that peace agreement has yet to be implemented. Until the peace agreement is fully implemented, we will remain to be a revolutionary organization. I highlight this passage simply because that is in direct contradiction to what was told us during the hearings on BBL. On the hearings on BBL, Madam Chairman, we are told that we are in a condition between MILF and the Philippine government where we have there is a cessation of military action or revolutionary action by your definition.
Sir,
so this contradicts that. In fact, even in our very first hearing, we were already told that the process of decommissioning had begun. But this does not seem to be consistent with that, Madam Chair. So I would just like to clarify so that we know on what basis we are talking here. Are we then? Can we now assume? I don't know if my interpretation is too severe, but can we now assume that we are still at war with the MILF?
Senator Marcos, I know we have to stand our ground. This is a very sensitive issue, and I feel that the representative is not authorized or high enough in their committee to be able to answer your questions properly. And so, with this particular, I think it's my assertion as chairman of the committee, you are not authorized to interpret. We just have to read it and take it at face value. One of the things that he mentioned here is he would like an executive session with us. We will entertain that possibility. On the other hand, as I've mentioned time and again, in an executive session, if we feel that it will not jeopardize national security and it is just to protect certain individuals, we will make this information public. This has to be clear to you. And I think that the next letter or the next message coming from you should be when he will actually show up in our hearing, because the invitation still stands at this time, and we expect him to be here, if not somebody who is authorized by the MILF to speak and answer the questions directly.
I just wanted to point it out, Madam Chair. I do not mean to hold up the proceedings, but I just wanted to point out that this passage that I read back from the letter of Chairman Iqbal is rather alarming. And again, I repeat, the reason why I find it particularly alarming is that it is in direct contradiction to the testimony that both sides of the both sides that signed the framework agreement and were pushing for the BBL. It is direct contradiction to the conditions that were described to us in our hearings in Mindanao and here in Manila. So just for the record, Madam Chair, that this is an alarming development, that we have returned to war with the MILF. That is worrisome, and I hope that the chairman will find time to come and explain precisely what this language means. Thank you, Madam Chair.
Madam Chair, on this very sensitive issue, can we request the Secretary Deles and Secretary Ferrer to comment, because we cannot leave this matter unattended to on the record, and all views are being heard. Yes, can we have Secretary Ferrer?
Good morning, Your Honors. On that issue of whether, in fact, MILF remains a revolutionary organization or not, we really have to see it in the context of the whole peace process. We are not at war with them, precisely. We have a ceasefire. But that ceasefire was broken on January 25, and that is the matter that is being investigated now. The circumstances that led to the breakdown of the ceasefire on January 25 around the events related to the law enforcement operations conducted by the Special Action Forces. We do have a roadmap that will lead to that full transformation of an armed group into an unarmed organization that is fully participating in the political, social, economic, and cultural processes of the country. And that is why part of our roadmap includes a decommissioning process whereby, in a gradual and phased manner, the arms will be turned in to an independent decommissioning body. The combatants will become ex-combatants alongside the political process that we have laid out, which is precisely
I'm sorry, Professor Ferrer, just a quick question. We applaud and we support the goals of these peace talks that we are having. These are ideal goals that we hope to achieve. But in the meantime, you can't blame the public and some of the resource people who feel that the peace talks is actually preventing also some of our operations to take place, to be able to defend and stand our ground. Now, my question to you is this, ma'am. Being a member of the government panel on the peace process, do you recommend the attendance of Mr. Iqbal in this panel? If yes, then at least we know that we are right in our assertions. If not, then please state the reason why. There may be complexities that we are not aware of.
heard the letter, and the letter said that they will be coming as soon as they are able to present their full report. I think we have to see it in the light of how the MILF operates. No single individual is able to undertake action without the full consent of the Central Committee of the MILF. And in this regard, the MILF Central Committee instructed him to come to this body when the full report is ready for presentation to the public.
But you agree, ma'am?
Yes, ma'am.
That it
I
is
agree.
yes.
It's very important that the MILF be here and the top leadership be here to be able to answer all the questions of the Senate.
Yes, it will demonstrate good faith, and in the meantime, Mr. Iqbal must honor the Senate with its presence. Actions speak louder than words also. Of course, it's all words being discussed here, but his mere presence will show good faith also in our discussions in the peace process. So we shall continue unless now we will ask for Secretary De Lima's, we shall now proceed with our discussions. Secretary De Lima, if you can please present the legal framework which may serve as a guide also for us.
Thank you, Madam Chair, and good morning to everyone, honorable members of the Joint Committee and all the other resource persons here. I had occasion, Madam Chair, to craft last night what I think is the legal framework for the discussions at yesterday's and then possibly today's proceedings. And these are just really my initial thoughts. We're still coming from a position where facts are yet to be completely established and where accountability is yet to be conclusively determined. Now, on the part of the DOJ, as a primary criminal investigative and prosecutorial agency of the government, we still have a long way to go before those criminally responsible in the incident are brought to justice. But we will arrive there one way or the other. In the meantime, what I can offer now is a legal framework from which to approach the various issues that have cropped up in the course of discussions on the incident, including those already raised at yesterday's hearing. The foremost legal question, and I think this becomes really very, very relevant in light of the letter of Mr. Iqbal, the foremost legal question that has arisen in this incident is the legal implication of the peace process on the criminal liability and administrative accountability of those involved in the incident. As stated yesterday, proceeding from a purely constitutional and legal standpoint, criminal liability on the part of the MILF in this case might not be different from ordinary situations where a crime was committed and that perpetrators who are identified are criminally liable unless they're able to successfully invoke either exempting or justifying circumstances. Administrative liability of those on the government side, however, is different. The peace process has generated a set of agreements, as everyone knows, on the cessation of hostilities between the government and the MILF. These agreements have been integrated in the operational guidelines of the AFP and PNP for law enforcement. Any violation of these guidelines should necessarily entail administrative liability. We have to contend with the fact that government security forces have bound themselves to observing certain rules of conduct in military and law enforcement operations under the regime of the peace negotiations and are therefore subject to disciplinary measures in the event of willful violation of these rules of conduct. And in any legal framework, the Constitution reigns supreme, as aptly articulated yesterday by Senator Gringo. Now, this is followed, of course, by the laws passed by the legislature and their interpretations as passed upon by the Supreme Court. Now, the question is, where does the peace negotiation and resulting peace agreements figure in this legal regime? Now, my take on the matter, Your Honors, again, these are just really my preliminary thoughts, is that the GPH-MILF agreements bind the parties to their terms as parties to a contract. And as a contract, it is therefore the law between the parties, but not the law of the country. Non-compliance with the terms of the agreement is a matter between the GPH and the MILF as negotiating parties. So in case of violations in the peace agreement, I see no legal sanctions on the part of the government, only political repercussions on the trust and goodwill between the two parties. On the other hand, in case of violations by the MILF, the GPH, the government, may choose to apply the peace mechanisms on cessation of hostilities as agreed upon between the parties, or proceed to apply the law, in this case the criminal law, on political crimes such as rebellion or ordinary crimes such as murder and direct assault. It can also choose to apply both, modifying its application of the law on criminal liability with any political settlement it can arrive at with the MILF in the future. In short, given this framework, the government, I submit, has two tracks in approaching the issue on criminal liability. It can approach it as the enforcer of the duly promulgated laws of the state, or as a party to a contract or agreement with the MILF. Or it can approach this issue from the perspective of both, that is, as the law enforcer and as a peace partner. The two, I submit, are not mutually exclusive. Applied separately, there would of course be political repercussions, especially if the approach is from a purely law enforcement or criminal liability standpoint, for the mere reason that the other party relies on the government to honor its commitments to the peace agreement. There is nothing in the GPH-MILF peace agreement instrument stating that in case any offense is committed by an MILF member in relation to rebellion or any other political crime, more so a common crime, during the regime of cessation of hostilities, the GPH is committed to suspend or forgo regular criminal proceedings against the MILF member and instead refer the same to the proper body created by the parties. Because as I mentioned yesterday, our laws do not stop to operate under a peace process or under a peace regime. Now, the closest commitment that can be relied to, I was going over the various documents, is the implementing operational guidelines of the GRP-MILF agreement on the general cessation of hostilities that was adopted in November 14, 1997. This agreement provides, I quote, "It shall be the responsibility of the GRP and MILF to take immediate and necessary actions to stop any violation and punish respective forces who violate this implementing guidelines and ground rules," end of quote, and that, quote, "the GRP and MILF will take appropriate actions on their respective forces who violate this implementing guidelines and ground rules," end of quote. Now, does this mean that the state commits to forgo criminal prosecution and leave the matter to the MILF, who shall take appropriate action against its erring members? For purposes of confidence-building measures, this might be a commitment that the GPH would want to keep. But in legal terms, no law prevents the GPH from exercising its power to arrest and prosecute criminal offenders regardless of an existing peace agreement that has no clear provision on the suspension of criminal action against political or common crimes committed by members of its peace partner during the peace process or negotiations. It can still proceed, of course, with arrest and prosecution, but the same will heavily impact on confidence-building measures, if not put an end to the peace negotiations or agreement altogether, but God forbid. Even assuming there is such an agreement on immunities, the same is only the law between the parties entered into for confidence-building measures. It is not the law of the state passed by Congress that has a mandatory and punitive effect in case of violation. Nothing in the laws of the Philippines would still prevent the state from not complying with this agreement on immunity to rebel negotiators, but of course at the risk of the other party withdrawing from the negotiations based on loss of sincerity, credibility, and trustworthiness of the GPH in pursuing negotiations. Because among the papers I saw, Your Honors, is that whatever security guarantee there is to the MILF in the peace negotiations involves only safe passage and immunity from searches and seizures, including arrest, but only to those directly involved in the peace negotiations. That's the limit of the immunity, or whatever immunity provisions are there and at present. Now, assuming also that the MILF did not notify the GPH panel of the presence in MILF area of criminal elements listed in the AFP-PNP order of battle, and I'm assuming that there is such a list because it's in the instruments that the GPH will submit to the MILF an order of battle or list of targets. Now, the same, if there is no such notification, the same shall be elevated to the GPH MILF peace panels for disposition as an act of non-compliance with the terms of the peace agreement on cessation of hostilities. However, approached from a purely criminal liability perspective, knowingly harboring a criminal, assisting a criminal, obstructing law enforcement operations for his arrest, and otherwise aiding in the escape of the targets are criminal offenses, which may be prosecuted by the government in the performance of its role as the enforcer of the laws of the state. And approached from a purely government law enforcement perspective, the criminal liability of the MILF members involved may be discussed in the following manner, only again as a matter of academic discussion because we don't have yet the full facts. Since MILF members who commit criminal offenses during the regime of cessation of hostilities are not immune from investigation, arrest, and prosecution under the agreements, the only way they can be exempted from criminal liability for the political crime of rebellion and ordinary crimes of homicide, murder, direct assault, etc., is under the provisions of the revised penal code on who are exempted from criminal liability. The exempting circumstance possibly relevant, I know which exempting and justifying circumstances are possibly relevant to the incident, in this incident, but because of the still incomplete and hazy facts, I would rather not express which are, or what are the applicable exempting and justifying circumstances, lest I'll be accused of preempting the investigation or even lawyering for any side or anyone. I have a discussion on those, but I cannot share this at the moment. Now, on the other hand, and by the way, whatever defenses they would have to be presented or would have to be proven during trial if and when it reaches that stage. But it does not exempt, in the meantime, the liable MILF members from investigation, arrest, and prosecution. On the other hand, if approached from the perspective of the government as a peace partner in a peace agreement or as the state actor in a non-international armed conflict, as manifested earlier by Professor Ferrer, or as the state actor in a non-international armed conflict, the criminal liability of the MILF can be limited to that of a non-state actor. This would mean, again, just for academic purposes, limiting criminal prosecution of the MILF to possible violations of humanitarian law as adopted from the Geneva Convention on War Crimes as integrated in Republic Act 9851, which is the Philippine IHL law. This implies recognition of the status of the MILF as a non-state actor involved in a non-international armed conflict. And from this perspective, I should say that criminal liability can be approached in this manner. What we had was a law enforcement operation, a legitimate law enforcement operation because it was for the implementation of outstanding warrants of arrest. But while initially a law enforcement operation, it gone awry, escalating into an armed conflict between government security forces and a non-state actor, enforcing a recognized defensive or protective position, and therefore may not be liable for ordinary criminal conduct, but only for criminal war conduct as a non-state actor under RA 9851. I'm careful enough to really phrase it as just may not be liable, because again, I do not want to make any categorical legal statement at the moment. This does not mean, however, that the agreement on a cessation of hostilities has already been terminated and that the forces have now reverted to a state of armed conflict once again. Neither side have made any pronouncement or declaration that there is now resumption of hostilities. That is the only way we can assume there is such if there is a formal declaration by either side. At the moment, there is none. So, as I said, this does not mean that the agreement on cessation of hostilities has already been terminated and that the forces have now reverted to a state of armed conflict once again. Far from this. It's far from this. The situation presents a factual, classic example of a violation of the terms and conditions of a peace agreement, which only calls for the operation of the mechanisms put in place in case of violations, but definitely not the ipso facto termination of the peace terms and reversion to a state of armed hostilities. And finally, any general amnesty that may be proclaimed in the future as part of the conclusion of the transitional agreements of the peace process or negotiations will have the effect of extinguishing all criminal liability in relation to covered crimes, generally political crimes or crimes related to rebellion, but not to common crimes. As to the criminal liability of the BIFF and other private armed groups which participated in the attack against the PNP and PNP-SAF, the same is unqualified by any extenuating circumstance such as an existing peace agreement or agreement with the government. Said groups are therefore liable to the fullest extent of the law for the range of possible crimes that they have committed during the Mamasapano incident without any possible application of exempting or justifying circumstances that are otherwise still or may be available to the MILF. This is for the simple reason that the BIFF and the PAGs themselves are per se illegal associations already engaged in criminal activities as defined under Article 147 of the Revised Penal Code, even before the encounter with the PNP, and therefore cannot, under any contemplated situation, invoke any exempting or justifying circumstance. Now, very briefly now, as conclusion, as a final portion of my position, we now go to the possible liability of government officials involved in the incident. As stated, nothing in our laws declares the act of government of non-compliance with peace agreements as criminal or illegal per se, so long as it is the adopted policy of the state as official government action. However, if willful non-compliance with the peace terms or termination of the peace agreement is not state or government policy, and what we have is a violation of the peace terms by individual public officials, said public officials may be administratively and even criminally liable. The various GPH-MILF agreements on the cessation of hostilities provide for the procedure on how arrests may be made by the AFP-PNP in MILF-defined areas or communities. These agreements on the cessation of hostilities provide that police and military actions throughout Mindanao shall continue, including the arrests of criminals. And of course, we now know that there are provisions on prior coordination and prior and notice about presence of targets in MILF areas, etc. In implementing these agreements, the AFP-PNP drew up operational guidelines. Assuming that the GPH-MILF procedure was not followed by individual PNP-AFP officials, this subjects the commanders concerned to administrative sanctions for non-compliance with the joint AFP-PNP revised operational guidelines for the AJAG. The administrative charges could either be gross insubordination or misconduct in the performance of official duties. Full compliance and bid for these operational guidelines would also justify the hesitance of the AFP to fully unleash its force and destructive resources in order to rescue or come to the aid of the concerned PNP force. We have heard yesterday General Katapang. The AFP was still mindful of the terms on cessation of hostilities with the MILF. It chose to follow the operational guidelines and decided not to compound a mistake with another one. Now, the administrative liability of public officials, however, may still involve criminal liability if the official participation or if the official participating in the execution of the law enforcement operation was not authorized by law to be part of the official decision-making apparatus of the government. The PNP, as if it was a military organization, would base this on the principle of the chain of command. However, approached from a purely civilian agency standpoint, not subject to military law, military justice, or military courts, the administrative and criminal liability of the PNP officials concerned should more properly be addressed using ordinary civil service rules for civilian agencies and the regular criminal justice system intended for civilians. As such, administrative liability may include grave misconduct and or insubordination, and criminal liability may include usurpation of authority as penalized under Article 177 of the Revised Penal Code. May I just say this for the appreciation of everyone? Some people may not agree with this. The concept of a chain of command is a military construct. Clearly, it applies to the AFP as a military organization of the state, but does it likewise apply to a purely civilian, albeit armed agency of the state, such as the PNP? According to the 1987 Constitution, I quote, "The state shall establish and maintain one police force, which shall be national in scope and civil character, to be administered and controlled by a national police commission. The authority of local executives over the police units in their jurisdiction shall be provided by law." That's Section 6, Article 16 of the Constitution. The PNP is not a military organization subject to the chain of command concept, strictly speaking. It is a purely civilian agency under a civilian NAPOLCOM with the president exercising administrative control and supervision over the DILG secretary and the NAPOLCOM as the chief executive and not as the commander-in-chief. As such, liabilities of PNP officials are determined using civil service rules and regulations applicable and common to all civilian agencies as enforced by the NAPOLCOM on members of the PNP, and not military law or court martials as enforced under the military justice system, the latter being applicable only to the members of the AFP. May I submit those thoughts, Madam Chair, for the committee's appreciation. Thank you.
Magandang umaga po sa inyong lahat. The joint public hearing of the Committee on Public Order and Dangerous Drugs, the Committee on Peace, Unification, and Reconciliation, and the Committee on Finance is resumed. For the committees, allow us to state that, number one, invitations anew have been made to individuals requested to be present today. The MILF Mohager Iqbal for the PNP, and also the PNP Controller, who I understand is present here today. For the retired PNP ARMM Chief Superintendent Noel de los Reyes. Senior Superintendent Mendez was informed of the hearing, but per the request of the PNP and some members of the committee should be invited to an executive session citing that the officer is handling key sensitive intelligence and information pertinent to national security and strategies. The committees will discuss this issue in a separate meeting. On the documents requested to be subpoenaed, I understand that the PNP and the concerned agencies will bring those documents hopefully submitted by today. Number one, the copy of the warrant of arrest for Marwan as requested by Senator Soto from the Board of Inquiry Chair Magalong. Number two, the intelligence packet as requested by Senator Honasan from the PNP, which the chair will have to examine first to determine whether this
Letter galing po sa kay Chairman Iqbal, address po sa kagalang-galang na Senator Grace po to the Senate, pursuant to the instruction of the Central Committee. At yung letter po ay sinabmit na po yata o binigay na po yata ni Atty. Raisa Jajuri. Nagsasabi po na and explaining na hindi po siya makakapunta pero meron siyang commitment that he will appear at kung mamarapatin po ng kagalang-galang po, Your Honor, with your pleasure, kung babasahin po ba namin yung sulat o ano po ang inyong disposition po, Your Honor. Thank you po.
Please po, pakibasa po yung kanyang liham. May kopya po ako pero dapat po malaman ng mga kasama natin. Go ahead, sir.
Thank you po, Madam Chair, Your Honors. 09 February 2015, Senator Grace po, Chairperson, Committee on Public Order and Dangerous Drugs, Senate of the Philippines. Dear Senator po, we thank you for your committee's kind invitation for us to attend the joint public hearings of the Committees on Public Order and Dangerous Drugs and Peace.
I'm sorry. Thank you for taking the time, sir. I know that you're busy also with the state visit of the Indonesian delegation. I would also like to acknowledge the presence of Secretary Gazmin, Secretary Ging Deles, Secretary Laila de Lima, and all the other members from the local government who may be present here today, the members of the PNP and the AFP. Also, Honorable Rosales, Chair of the CHR. Yesterday, we discussed the chain of command issues, the questions as the involvement of the MILF. I would like to ask the representative of the MILF if perhaps we will have today the presence of Mr. Iqbal, and then the glaring communication inefficiencies of the equipment and coordination procedures, and of course the participation of Mr. Napeñas and also Mr. Purisima. So to begin, I would like to ask the MILF panel, the MILF representative who will be here today. Is it still you, sir?
Magandang umaga po, Madam Chair, Your Honors. Meron pong
Senator Honasan, if ever, Senator Recto, Aquino, Pimentel, Cayetano, Cayetano Alan, Villar, Cayetano Pia, Angara, Legarda, Osmeña. And the questions submitted, Senator Bina and Marcos. And the questions submitted by Senator Revilla. For those who weren't present here today, magsitayo po tayo para gawin ang ating panunumpa. I think Honorable Rosales, yung mga wala po kahapon at yung mga hindi po sigurado sa kung ano yung sinumpaan ninyo kahapon, tumayo lang po muli.
May I request those resource persons who were not present yesterday and those who were not able to take their oath yesterday to please stand up and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this investigation in aid of legislation on the Mamasapano incident? I do. For the record, Madam Chair, the resource persons affirm their oath.
Salamat po. I would like to acknowledge the presence again of Senator Rojas. Thank you for taking the time, sir. I know that you're Secretary Rojas. This packet can be divulged to the public or should be part of our official documents. In addition, the approval sheet of the Operation Exodus, the PNP SAF after operations report, and the communication net annex as requested by Senator Marcos, also from the PNP SAF to submit. The operation plan as requested by this representation, the PNP or Director Napeña should also submit this. We have for today additional invited guests, Chairperson Loretta Rosales of the Commission on Human Rights. As we resume the interpellations, may we remind the members that 5 minutes per question is allotted per senator, and you will have a chance to ask more questions in the next round. And before we start with our interpellations again, may we request Secretary De Lima if she can. I think she has a presentation on the legal framework for the Mamasapano incident. I think that we will be guided greatly by this because we are also constrained by several legal provisions. So we will ask for her presentation. The sequence of questioning will be Senator Drilon, to be followed by Senators Binay, who I think will give her time to